The James Comey prosecution was destined to collapse, and it did. But the court's dismissal does not end the story. The part of the story that matters most is just beginning, because we need to examine how a case with no probable cause made it into federal court at all. In this video, you and I will look at the videotaped testimony that led to the indictment and examine, from a prosecutor's perspective, why this case never should have been brought, and why the conduct of Attorney General Pam Bondi and Attorney Lindsey Halligan demands accountability. I'm Bill Hauser. I was a federal prosecutor for more than 30 years. In this video, you and I will watch the testimony that led to James Comey's indictment, and I'll explain from a prosecutor's perspective why there was no probable cause to charge him. I'll also walk through how Attorney General Pam Bondi and Attorney Lindsey Halligan bypassed normal Department of Justice procedures, ignored attorney disciplinary rules, and violated federal law in order to pursue a prosecution the President was demanding. And finally, I'll explain why their conduct and the conduct of others involved in this case must be met with accountability. The Comey indictment was dismissed because Attorney General Pam Bondi illegally appointed Attorney Lindsey Halligan as interim U.S. Attorney. Here's what President Trump had to say about the dismissal.
They got out on a technicality, and you'll see what happens from here on. But if you look at the actual charges, I think anybody that looks at it very fairly would say, boy, are they guilty.
Let's follow the President's suggestion together and look at the charges and the evidence fairly. And let's see if we say, boy, is Comey guilty, or if we say, boy, this was an abuse of prosecutorial power. Let's start with the question of whether there was probable cause to charge Comey. Department of Justice policy requires that, at a minimum, before a prosecution can be initiated, there must be probable cause to believe a crime was committed by the person to be charged. The policy requires that a prosecution be brought only when the admissible evidence will probably be sufficient to obtain and sustain a conviction. Comey's indictment stemmed from his video-recorded testimony before the Senate Judiciary Committee in September of 2020. So you and I can watch the actual testimony and analyze for ourselves whether his statements were prosecutable under DOJ's policy. The two-count indictment charges him with making false statements and obstructing by making those false statements. If there are no false statements, there's no obstruction. So let's focus on the false statements charge. Comey's indictment was based on alleged lies he told in answer to two questions posed by Senator Ted Cruz. Before asking the questions, Senator Cruz offered his opinion that Comey's previous testimony in 2017 contradicted statements he said were made by Andrew McCabe. And it's important to note, McCabe's account is legally irrelevant. The question isn't whether their stories differ, it's whether Comey himself made a false statement under federal law. Let's listen to the senator's first question and to Comey's testimony. And note that the testimony took place during the pandemic, so Comey was testifying from his home, not in the same room with Senator Cruz.
Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. Who's telling the truth?
I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017.
Comey's answer to the first question was normal and natural, but it wasn't a direct one. Senator Cruz asked, "Who's telling the truth?" A direct answer would have required Comey to say either, "I am telling the truth," or "Andrew McCabe is telling the truth." Instead, Comey said, "I can only speak to my testimony. I stand by the testimony you summarized that I gave in May of 2017. Let's break that down the way a federal prosecutor would. His first point, "I can only speak to my testimony," is true. Comey cannot know whether Andrew McCabe intentionally lied, and federal law does not require a witness to speculate about another person's state of mind. His second statement, "I stand by my testimony," is also literally true. A person can stand by a previous statement, whether that statement was accurate or not. The phrase simply means they are not retracting it. It does not answer whether the original statement was true. Here's a simple example. If my neighbor tells me there's no snow in my yard, and I later ask whether she was lying, she might respond, "I stand by what I said." That response does not reveal whether her earlier statement was true or false. It only tells me she's maintaining her prior position. This matters because under long-standing Supreme Court precedent, the Bronston decision, A literally true but evasive answer cannot form the basis of a false statement prosecution. If a witness gives a response that's literally accurate, even if it's incomplete or designed to avoid the question, the law places the burden on the questioner to ask a follow-up. Comey made clear in his motion to dismiss the indictment that his 2017 testimony was truthful, but under Bronston, even if it were not, his answer to Senator Cruz's first question was still literally true, and therefore can't support a false statement charge as a matter of law. Now let's look at the second question Senator Cruz asked Comey, and Comey's response.
So your testimony is you've never authorized anyone to leak. And Mr. McCabe, if he says contrary, is not telling the truth. Is that correct?
Again, I'm not going to characterize Andy's testimony, but mine is the same today.
A direct answer would have required Comey to say either, correct, Andrew McCabe is not telling the truth, or incorrect, Andrew McCabe is telling the truth. Instead, Comey responded, again, I'm not going to characterize Andy's testimony, but mine is the same today. Just like his first answer, this response was normal and understandable, and once again, not a direct answer. His first point, refusing to characterize Andy's testimony, is literally true. Comey cannot know what McCabe believed, and as I said before, federal law doesn't require a witness to assess another person's intent or honesty. His second statement, mine is the same today, is also literally true. Testimony can be the same today regardless of whether it was accurate or mistaken in the past. The phrase tells us nothing about truth or falsity. It simply indicates that he's not changing his prior account. Once again, because Comey's answers were literally true, they cannot support a false statements prosecution as a matter of law under the Supreme Court's Bronston opinion. Without a false statement, there's no obstruction charge either, because the obstruction count depends entirely on the existence of a false statement. Because Comey's answers were literally true, there's no probable cause to charge him. Prosecutors have an ethical duty not to bring charges without probable cause. In Florida, where both Attorney General Bondi and Lindsey Halligan are licensed, Rule 4-3.8a of the Rules of Professional Conduct states that, quote, the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause, end of quote. No competent ethical prosecutor would seek an indictment for these statements. The reported facts of this case support the conclusion that Attorney General Bondi and Lindsey Halligan knew there was no probable cause to pursue the case, but pursued it anyway. Interim U.S. Attorney in the Eastern District of Virginia, Eric Siebert, a competent ethical career prosecutor appointed by Bondi, resigned according to news reports rather than pursue baseless charges against Comey that were being demanded by the president. U.S. attorneys don't resign casually. The fact that he stepped aside rather than pursue this case signals that he knew the case was defective and was unwilling to attach his name to it. Once he refused to bring the case, Bondi had to bypass normal DOJ safeguards to force the indictment through. Siebert's resignation came hours after President Trump told reporters at the White House that he wanted Siebert out. Once Siebert resigned, President Trump accidentally posted a private message to Pam Bondi on his Truth Social platform. Pam, I have reviewed over 30 statements and posts saying that essentially, same old story as last time, all talk, no action. Nothing's being done. What about Comey, Adam, Shifty Schiff, Letitia? They're all guilty as hell, but nothing's going to be done. Then we almost put a Democrat-supported U.S. attorney in Virginia with a really bad Republican past. A woke rhino who was never going to do his job. That's why two of the worst Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him, and there's a great case, and many lawyers and legal pundits say so. Lindsey's a really good lawyer and likes you a lot. We can't delay any longer. It's killing our reputation and credibility. They impeached me twice and indicted me 5 times over nothing. Justice must be served now. President DJT. Siebert's resignation set the stage for Pam Bondi to do the president's bidding, to pursue an unfounded prosecution against one of the president's critics. The 5-year statute of limitations was about to run on Comey's 2020 testimony, which meant Bondi had only days left to bring charges. If she didn't act immediately, the case would expire forever. That deadline created intense pressure to move fast, and this is what she did to make sure the president's demand for a prosecution came to pass. First, at the president's request, she appointed Lindsey Halligan as interim U.S. attorney for the Eastern District of Virginia. That appointment was illegal because the law governing interim U.S. attorneys requires that the district court, not the Attorney General, make the appointment after an interim U.S. Attorney has served for more than 120 days. This is the reason the Comey case was ultimately dismissed. 4 federal district courts have now found that the appointment process Bondi used in this case and 3 others was unlawful, and a unanimous panel of the Third Circuit Court of Appeals, that is, judges appointed by both Republican and Democratic presidents, has already affirmed one of those cases on appeal. The U.S. Attorney is the chief federal prosecutor in a district. Lindsey Halligan had never handled a criminal case. She was unqualified for the position. I should pause here to mention that the U.S. Attorney's Office for the Eastern District of Virginia is one of our premier U.S. Attorney's offices. It's vital to protecting our national security. It's located in the district where the Pentagon, CIA, Defense Intelligence Agency, and numerous other military, intelligence, and law enforcement agencies are located. It's where we had our only trial of a September 11th conspirator, where we charged Somali pirates, where we prosecuted an al-Qaeda plot to kill former President Bush, and where ISIS material support cases are routinely handled. Because the Eastern District of Virginia handles some of the nation's most sensitive national security matters, this is the key U.S. Attorney's Office where, at the request of the President, Pam Bondi illegally appointed an unqualified lawyer with no prosecutorial experience so she could quickly pursue an unfounded indictment of a critic of the President. Second, Bondi, Deputy Attorney General Todd Blanche, and Lindsey Halligan, all of whom acted as the President's personal attorneys before assuming public office, removed all local career prosecutors from the case and took over direction of the case themselves. Here's the President confirming that.
Well, I can't tell you what's going to happen because I don't know. You have very professional people headed up by the Attorney General, Todd Blanche, and Lindsey Halligan, who's a very smart, good lawyer, very good lawyer. They're going to make a determination. I'm not making that determination. I think I'd be allowed to get involved if I want, but I don't really choose to do so.
It's extraordinarily unusual for top leadership at DOJ to assume direction of a single criminal case. In fact, this appears to be unprecedented in modern DOJ history. Halligan presented the case to the grand jury all by herself. Indictments are typically presented by career federal prosecutors, assistant United States attorneys. Never once in more than 30 years at DOJ did I ever hear of a U.S. attorney seeking an indictment alone. It's extremely rare. Halligan sought a 3-count indictment, but the grand jury rejected one of the charges she presented. Let me explain how rare that is. I was a federal prosecutor for more than 30 years and presented hundreds of cases to federal grand juries. Because DOJ normally uses a strict multi-level review process, I never once had to stand in open court and tell a judge that the grand jury returned a no true bill on any count of an indictment I handled. In fact, I'm not aware of it happening to any of my colleagues either. Third, Bondi and Halligan ignored a declination memo prepared by career prosecutors that found no probable cause existed to charge Comey. ABC News reported on September 25th, just hours before Comey was indicted, that prosecutors in the Eastern District of Virginia provided Halligan with a detailed declination memo explaining why no probable cause existed, but that Halligan planned to present the indictment to the grand jury anyway. If this is true, it's a violation of DOJ policy, a breach of the rules of professional responsibility, and an extraordinary abuse of prosecutorial power. Let me explain what a declination memo is. Typically, a line career federal prosecutor will write a declination memo when he or she believes probable cause does not exist. That memo moves up the chain of command to deputy criminal chiefs, to the criminal chief, to the first assistant United States attorney, and finally to the U.S. attorney himself or herself. By the time the memo reaches the top, it's passed through multiple levels of review, and a determination that no probable cause exists is typically not controversial. Probable cause is a very low standard. Competent prosecutors readily know whether admissible evidence will likely be sufficient to obtain and sustain a conviction as required by DOJ policy. Because Comey's testimony was literally true, everyone who reviewed that memo knew there was no probable cause to indict. The judge in Comey's case specifically asked the DOJ prosecutor whether a declination memo existed. That prosecutor said he'd been instructed by the Office of Deputy Attorney General Todd Blanche not to discuss whether a memo existed. I don't know about you, but after reviewing Comey's testimony the way the President suggested, I'm not left thinking, boy, was Comey guilty. It seems far more clear that the case against him was an abuse of prosecutorial power. Let me know in the comments what you think. Because the case was dismissed on the narrow ground that Lindsey Halligan was unlawfully appointed, The court never had to address Comey's motion to dismiss based on vindictive prosecution. But that issue still matters because when we examine it, the motive behind the actions of the President, Pam Bondi, and Lindsey Halligan becomes clear. And it becomes clear just how blatant the abuse of prosecutorial power was and why accountability is essential. We need to look no farther than the President's social media posts to understand the vindictiveness behind this prosecution. They impeached me twice and indicted me 5 times over nothing. Justice must be served now. In other words, they came after me, now you go after them. The President ties his demand for prosecution directly to his claim that wrongs were done to him. This is the definition of vindictiveness. And if you still have doubts about the President's and Pam Bondi's vindictiveness toward James Comey, then I suggest you watch my video on Bondi's firing of Maureen Comey, the daughter of James Comey, an extraordinarily talented, Harvard-educated assistant United States attorney in the Southern District of New York. She was fired by Pam Bondi with no cause, simply because her name is Comey. What happened here was a betrayal of one of the Justice Department's primary obligations, to ensure that the law is applied fairly, impartially, and independently, without fear, favor, or political influence. Because the rule of law depends on prosecutors applying power within limits, any breach of those limits threatens not just a single defendant, but the integrity of the department itself. Federal prosecutors wield enormous power. Our system only works when that power is exercised within the rules. When prosecutors break those rules, accountability is the only mechanism that prevents the system from breaking down. Because ignoring misconduct tells future prosecutors that the rules don't matter. Bondi and Halligan's actions in the Comey case threaten more than one defendant. They threaten the integrity of the Department of Justice because misconduct becomes precedent unless it's met with accountability and a reckoning. If you found this discussion helpful, please subscribe to my channel and remember, where law rules, justice follows.